Those case people versus Bobby Beach.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Beach, who should be present via Zoom. For the record, Your Honor, I'm surprised he's not here. I've talked to him.
Me too.
I have talked to him several times this week, including this morning when I sent him.
Oh,
there he is. Mr. Beach, could you please unmute and state your name for the record?
Next time, change your name. State your name.
Okay, Bobby Beach.
Okay.
Thank you, Your Honor. My client wishes to set this matter for preliminary exam. Discovery is complete to our knowledge.
People have their witnesses available on the 13th.
I don't know if I can have that done by the 13th.
Gotcha. He's out of custody, so preliminary examination in person without objection will be set August 20th, 2024, 9 a.m. That is before Judge Valvo. Bond will continue.
Thank you, Your Honor. You said August 20th?
Yes.
Thank you, Your Honor.
Thank you.
There's a bond violation. Well,
Is there?
he just, the report is dated July 31st. This test on the July.
Why'd you miss your test on July 22nd?
What day was June 18th? Because I could have believed I went up there and they said, this is Juneteenth, some type of Black history. They're not even testing the day.
Really? Really? Some kind of?
What do you mean, some kind of? I'm telling you what they told me at the door.
Kind of Black history thing?
I'm out here in the street. I go test every week. I don't miss a beat, and I give y'all $50 a week to test for marijuana that I have a marijuana card for.
Mr. Beach?
Okay.
Mr. Beach?
All right, so I'm going to start again. On July 22nd, I'm now out of June. July 22nd, I have a report that you missed a test.
I have all my receipts. So I don't miss no tests. So a urine test, I don't miss no tests. I go to all my tests. I pay y'all the money. And y'all tested me for marijuana. And I have a card for marijuana. So the taxpayers is paying for me to be tested for marijuana.
Mr. Beach?
Okay, so we can have this in person. Why don't we deal with this in person? We can do it this afternoon. He available?
I do not know, Your Honor. I have not been able to.
Okay, 3 o'clock this afternoon. We'll set it for a bond hearing. Beautiful. Thank you. All
right, Mr. Beach.
Put that on my 3 o'clock. I'll see you then. Thank you.
Please give me a call.
Yeah, you might want to do that. Court calls the case. People versus Leon Odom. Court calls the case. People versus Bobby Beach.
Andrew Tripp is appearing on behalf of the people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Beach, who stands to my right. Please state your name for the record, sir.
Bobby Beach.
Thank you, Your Honor. I have been able to have a discussion with my client in regards to his missed test on July 22nd.
I hope it was shorter than the one we had this morning.
It was longer, Your Honor. He does acknowledge that he does miss the test. He apologizes for both his missed test and the miscommunication this morning. He has been going through a lot. He did provide me with an obituary. His father did just pass on July 23rd of last month. We would respectfully request that the court admonish him for his missed test and allow him to continue while on bond. I did note that when reviewing the report that it was labeled as a progress report. He does have a valid medical marijuana card, and that is what he has. His only positive tests have been for that, which he has provided the card to community corrections. We are respectfully requesting that he be able to continue out on bond.
Can I just ask, when we were on Zoom, why couldn't you just tell me that? My headphones were going out. I was trying to put them on, Judge Simpson. Hang on. The only question I asked you was why you missed that test. That's all I asked you, and you went off into whatever.
I thought you said June. I was thinking about.
I know you went to June and then talked about the Black holiday, the thing you probably really should know about, given your heritage. But outside of all of that, I asked you about the last missed test, and you started to act a fool. That's all I can tell you.
I'm going through it. I apologize. I'm sorry. I really do. I'm sorry. I gotta go to this funeral tomorrow. My dad 90 years old, gone. Worked at Ford plant for right there, gone. I just apologize.
Anything from the people?
No.
It's going to indicate no action taken on the missed test of July 22nd, 2024. This matter will then continue to the August 20th, 2004 date for preliminary examination before Judge Valvo. I suggest that you conduct yourself a whole heck of a lot better than you conducted yourself before me.
I apologize. We kept the same date you previously set.
The August 20th, yes.
Thank you, Your Honor.
Waiting before you get fired. So. I love that.
Yeah, no, that was good today. Court calls case People versus Devin Schiller.
Mr. Sinatra for the people.
Assistant Public Defender Davey Leva on behalf of Mr. Schiller, who is approaching from my right.
Your name, sir?
Devin Matthew Schiller.
Thank you.
Your Honor, with the court's permission, I'd like to request to address bond prior to addressing the PCC. As Mr. Schiller is in custody, his position is whether he would like to waive or continue to adjourn to seek a misdemeanor resolution is dependent on whether he's able to be released.
Okay, go ahead.
Thank you. I would be requesting a release to home confinement with a release to work. Mr. Schiller wants the opportunity to show the court and the people he is able to remain sober while out of custody. He will not commit any more crimes or have any bond violations. He does have an intensive outpatient appointment at Dawn Farm, which he set up through the jail. It is at 9:30 a.m. on Monday. Additionally, he tells me he still has a job available for him at Johnson and Selvio Properties, where he's the maintenance.
Didn't I hear the same bond argument before?
Not for me, Your Honor.
Oh, so it's different from you.
I'm not aware if the argument is identical to one previously turned to. I certainly apologize to redundant, Your Honor.
May I address the court?
May I continue, Your Honor?
Sure, why not?
Thank you, Your Honor. Mr. Schiller is concerned that if he is in jail longer, he'll lose his job. He does understand that if he were to have the privilege of a bond granted, he immediately remanded if testing positive. He does expect to be tested very consistently. Mr. Schiller also likes the court to know that he will be able to post a low cash balance, say 10% privilege, if that were to be granted.
Is there anything else?
No, Your Honor.
What did you want to tell me, sir? If that's okay with your attorney.
Yeah, I was just gonna let you, like, when you said, that the same argument has been made, that was when I first came in before I did 3 weeks in jail over this bond violation. It was on the 11th when I was still on bond, when I first got remanded. The drugs are out of my system now, so when I do go drug tests, like, they will be negative.
Is there anything in place regarding any type of treatment or
Yes, Your Honor.
support? What?
He has an intensive outpatient appointment with Dawn Farm on Monday.
At 9:30 a.m.
Are they gonna come see him in the jail?
No, Your Honor. He did set it up through Sarah Stewart at the jail. However, my understanding is he does need to be released in order to attend that appointment.
Any response from the people?
Well, you remember the community corrections report that brought him.
Yes.
Okay, so I would add some additional context. There was a misdemeanor case in 15th District Court, and I put a plea offer together, which was to reduce this felony to a misdemeanor if he pled on the misdemeanor assault and battery case. He didn't want to take that offer. He let that case come up for final settlement conference. Victim wasn't present, case got dismissed. Why I'm pointing that out to you is that it was an assault and battery where the victim called him a crackhead and he hit the victim, right? So this defendant has a history of theft related convictions on his record, including home invasion, FTD. He got HIDAs for those, but he's had misdemeanor retail frauds. He's had controlled substance use case convictions in the past. He has a demonstrated track record of drug use and or theft, which let's use our logical conclusion of why he's stealing things in the first place. I wouldn't stick my neck out for him right now. And I told the public defender yesterday, what mitigation information would you want to share with me for me to consider reducing this felony to a misdemeanor? And I'm not trying to be tough with the public defender, but I want an honest accounting from the defendant about it. So I wouldn't agree to reduce this to a misdemeanor right now. And I definitely would be skeptical about him being released on bond when he was testing positive for fentanyl and really misleading the court about, I believe he was saying it's how long it stays in the body. And he said he had taken it a month previously, something like that.
I remember.
Right. So I think you know where my position is on this.
Okay. Crystal.
Thank you.
And I just want to emphasize that Mr. Schiller is eager to have the opportunity to earn a misdemeanor resolution, and he believes he'll be best able to do that if he is released. He's not asking for a personal bond necessarily. He's not asked to be released without conditions. He's asking for a home confinement other with release to work and very frequent drug testing, where if he violates again, he understands he'll be immediately remanded. And that
Like he was this time.
yes, Your Honor, and that he would not have the
Motion for bond
opportunity.
reductions denied.
Thank
do
you,
you
Your
want
Honor,
to
we
do?
waive it this time.
You'll waive?
Yes.
You understand you have a right to a preliminary examination?
Yes.
You understand that by waiving that proceeding, you'll not have that hearing? That at that hearing, the people have to show by probable cause that the offense alleged was committed and that you committed it. You
Yes.
understand you won't have that hearing and you'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
We do.
Preliminary examination haven't been waived. Defendants bound over in single count.
Thank you, Your Honor. We acknowledge receipt of the information, waive formal reading and stand mute.
Defendant, every way, formal reading, standing mute. Court will enter a not guilty plea. Pretrial in this matter will be set for
August 12th at 1:30 before Judge Slate Monday.
August 12th, 2024, 1:30 before Judge Slay Monday. Bond continued.
Thank you, Your Honor.
Thank you. Yes, sir. Court calls the case of the people versus Boise Smith.
And good morning, Your Honor. Sydney Rushing appearing on behalf of Mr. Smith, who appears to my right. Will you please state your name for the record?
Boise Smith.
Thank you. Your Honor, today is the date and time set for a probable cause conference. At this time, we would like to request a preliminary examination. We have received discovery. We have went over it with my client, and at this time, he would like to schedule that exam.
People have their witnesses available on the 13th.
We will do our best, Your Honor.
Preliminary examination in person will be set August 13th, 2024, 9 a.m. That is before me. Sit at 9 or 1
Oh, I'm sorry, that's it. Wow.
at 12 noon before me.
And Your Honor, may I address bond?
You may.
Your Honor, as we all know, the purposes of bond is one, for the protection of the community, and my client returns to court. He will do so. He understands that he has that next date of August 13th at noon, in front of Your Honor here. Your Honor, his bond currently is set at 100,000 cash surety. It's an unaffordable bond for him. He is not able to post that. Your Honor, I am asking that you consider a personal bond with a GPS tether. I think that this is an isolated event and allegations with an isolated person. So I don't believe the community at large is in danger. So I think a GPS tether, which is a little bit of a less restrictive means than 100,000 cash surety that's unable to be posted, would suffice. And I'd ask Your Honor to consider that.
Response.
Judge just got off parole in 2020 for a homicide charge. This involves strangulation. He was strangling her and said, "Bitch, I'm gonna kill you." He hit her multiple times. He's also contacted her while in jail, or contacted the phone number that we have 31 times. So I would ask to keep on the same.
Anything else, Ms. Wright?
Your Honor, just briefly, the parole was a juvenile case, and as it relates to the allegations of strangulation, I have seen that. I've also seen discovery. I've seen pictures in the discovery where there is zero redness anywhere on a neck that was seen just
Were there
after
children present at this alleged?
That's what the allegations I see that were that the children, I think were either there or she took them from the location.
Motion for bond reductions denied.
Thank you so much.
Bond will continue to stand. All right, court calls case, people versus Sean Carlson.
This is Senator Donahue. Leave on behalf of Mr. Carlson. Voting for my right.
Today is the next date set for a probable cause conference. We have reached a plea agreement, and that form should have been tendered to Your Honor and to defense counsel.
I do have it. The form indicates that the defendant will be pleading guilty to child abuse, 4th degree, punishable by up to 1 year, up to 5 years probation. And upon a successful plea to that charge, count 1 would be dismissed. There is no other agreement.
That is correct, Your Honor. Awesome.
Sean Matthew Carlson.
Has he signed an advice or rights form, counsel?
Not to my knowledge, Your Honor. I can have him sign one right now.
Attorney without a pen.
Your Honor, that has been a frequent occurrence for me, unfortunately. Thank you.
You know, that's why they made pockets. You can solve that.
It's absolutely true.
Have the defendant sworn, please.
State your name.
Sean Matthew Carlson.
Sir, it is this court's understanding that you're going to plead guilty to the charge of child abuse 4th degree. That is a misdemeanor punishable by up to 1 year incarceration and up to 5 years probation. Is there a maximum fine on that?
1 year or probation or up to
5 years, no max.
1 year
All right.
jail or probation up to 5 years, no monetary.
Gotcha. All right, you understand that, sir?
Yes, sir.
All right. Now, you also understand that pleading guilty in this case, that I would not be your sentencing judge and you would be sentenced before Judge Perry in the 15th District Court.
Yes, Your Honor.
All right, understanding all of that, do you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You had signed an advice of rights form today, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
You'll see it on the podium. Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty?
No, Your Honor.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
and because you believe that you're guilty of this offense?
Yes, Your Honor.
February 20th, 2024, at the location of 3137 Homestead Commons, Apartment 5, Ann Arbor City, Washtenaw County, State of Michigan. Did you have care or custody of a minor child?
Yes, Your Honor.
And what did you do with reference to that child?
I hit him in the arm with a closed fist.
All right. How old was the child?
10 years old at the time.
All right. And in doing so, you were doing something in excess of discipline?
Yes, Your Honor.
And that did, you would admit, cause physical harm to that child?
Yes, Your Honor.
I'm sorry, I didn't hear the initial factual basis for the plea.
Which part?
What did he say he did to the child?
He said he hit the child with a closed fist in the arm.
Okay, so if I could just read and make sure that this is correct for the record, the police report, Sean approached Anthony, the minor child, and punched him with a closed fist in his face, causing his head to snap against the wall. Is that correct, sir? Did that happen?
That's not what happened.
Okay, there's a big difference between the arm and the face.
Yes, Your Honor, I do believe it's a sufficient factual basis, however.
Was his nose bleeding when the police arrived, sir?
No.
Your Honor, would the court accept a no contest plea?
I don't know if the deal was continued upon him pleading guilty, but obviously we have two very, very different versions of what happened. I mean, either the child got hit in the face or the arm, and either the child was bleeding or he wasn't. Why don't I do this? Why don't I pass the matter? Counsel, why don't you talk to your client?
Yes, Your Honor.
And then I'll call you guys back up and let's see what we can do.
Thank you, Your Honor.
Thank you. And recall the case, People versus Sean Carlson.
Senior advisor again on behalf of the people, Your Honor.
Assistant Public Defender Davy Lieb on behalf of Mr. Carlson, who stands to my right. Mr. Carlson, can you state your name, sir?
Sean Matthew Carlson.
Thank you for the court's patience, Your Honor. I have had additional discussion with Mr. Carlson as well as the conversation with the prosecutor. At this time, Mr. Carlson would like to enter a no contest plea.
Do I have?
I don't have an objection to that, Your Honor, and I have marked the police report as People's Exhibit 1, Ann Arbor Police Department Report 24-7818, and marked the injuries to the child and the relationship and the statement from the report. And ask that be admitted on the basis of.
Any objection, counsel, to the court reviewing this report?
No objection, Your Honor.
That being 24-7818 of the Ann Arbor Police Department. Sir, you and the understanding is you wish to plead no contest?
Yes, Your Honor.
The basis for the no contest plea, counsel?
Lack of memory as well as potential civil liability.
All right. You understand that all the rights that I explained to you apply to a no contest plea?
Yes, Your Honor.
And everything is exactly the same. It's just that you are pleading no contest to the charge. You understand that?
Yes, Your Honor.
So to that charge, how do you plead?
No contest.
view of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court?
Yes, the people are saying.
Defense is likewise satisfied, Your Honor.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court. Sentencing in this matter will be
August 30th at 9:30 before Judge Terry.
August 30th, 2004, 9:30 before Judge Perry.
Your Honor, you could just check on the form that it was a no contest plea, and the one other, additional part that I believe was discussed between parties is there will not be a delayed or a deferred.
Is that correct?
That was discussed, Your Honor.
Well, was it agreed to?
In terms of my discussion with Ms. Willenbring, I believe I just asked if she would be offering one. I don't know that we necessarily agreed that we would not be seeking one. However, that may have been a discussion with the previous attorney.
What?
That may have been a discussion with the previous attorney on the case.
It's just maybe a miscommunication. No, we're not offering one means that the reduction happens and we're not offering it and he's not seeking it.
And that is correct.
So that is correct.
Yes, Your Honor.
He's not going to be seeking it delayed or deferred.
That is correct.
You understand that, sir?
Yes, sir.
He's not around this child currently, is he? I mean, probably the worst thing is he told me something. I'm looking at the police report. He's telling me he hit him in the arm. There's a clear injury to his face. And
I know that CPS is involved. I would like to think that they remained involved, although I don't know that for certain.
He did complete a reunification process through CPS, Your Honor.
And so what's the status currently?
The child is residing with Mr. Carlson under the guidance of Child Protective Services.
What's that mean?
He completed a reunification process. My understanding is that they maintain some involvement.
Okay, so what is that involvement?
Just recently, my CPS, social worker just closed the case out just early July. Since then, I've also been going through a lot of parenting classes, and I'm going through some other things through affiliates of with protective services with like orchards and other.
Are you taking parenting classes now?
I completed mine. It was a 10-week course.
Pardon?
It was a 10-week course.
And so you're doing, there is nothing, the child is just with you.
Yes. And protective services thought it was still okay for him to be with me.
And I've got some serious concerns with a man that can't realize that he didn't hit a child in the arm, but hit him in the face and coming before a court and telling me that. So you're lucky to be leaving today.
Fair enough.
You may leave.
Thank you.
Thank you.
Court does call the case of the People versus Holly Brown.
Andrew Childers appearing on behalf of the people.
Erica Julian appearing on behalf of Holly Brown. Holly Brown.
All right. Okay.
Your Honor, and this is in an effort to expedite things. May Miss Julian and I approach the bench?
You may.
Thank you.
Okay, on the Holly Brown matter. I'm speaking with counsel at the bench, and I'm not going to go into all of the details, and I don't think they need to be gone on the record because some of them, I think Ms. Brown, for privacy reasons, I'm not going to go into. I will say this, that there is still some question, not really in the court's mind as to the bond violation, but certain things are occurring simultaneously that could mean one thing or another, and I'm going to give counsel time to try to sort that out regarding the Scram unit. Meanwhile, I also don't think that pending this hearing, that it's advisable necessarily to keep Ms. Brown incarcerated. Now, Ms. Brown, I'm gonna tell you this, and I'm doing something backwards from what normally happens. Normally, what would happen to somebody may start out on a sober link. They can't keep up with the sober link, then they go on a tether, or a scram tether. You're on a scram, there are issues with the scram. And the suggestion is made, and I'm agreeing to it, that we're gonna put you on a sober link prior to your release. The community corrections is gonna need to get you a sober link. Now, I told your attorney, and I'm gonna tell you, I'm gonna give you that opportunity, but it's gonna require 3 blows a day. Given what I've seen regarding the scram report, I'm not going to be very tolerant if you miss a blow. You understand that?
I do.
And I'm not, Miss Julian will explain to you if I get in one of my moods that I'm not even gonna hear your reasoning. So you might as well can save the oxygen. I'm gonna give you this opportunity. I'm gonna adjourn the PCC out to August 22nd. We will see exactly how you are doing from there. And then I'll make my final determination in terms of what I'm going to do. And after receiving any additional information from counsel regarding. I think that's everything that we had.
Yes, sir. I think we just have it still here.
From community corrections?
Yes.
Yes, I know. Hi.
I was going to ask him specifically, is there a way to be able to pair for a silver link today?
I had the here.
Thank you.
Appreciate that. All right. Okay. So we'll see you on the 22nd.
How do you take your coffee?
Pardon?
How do you take your coffee?
I don't drink coffee.
Okay, and I won't have one right at the meeting I go to this evening.
Okay, all right. Take care. Actually, I do drink coffee way too much, but I'm not gonna tell you that.
Thank you, Judge.
Take care, Miss Brown.
14A District Court for the County of Washington, State of Michigan is now back in session. The hour for Mr. Day said,
You may be seated. And we're ready for it. Court does call the case of the people versus Fareed Jar.
Jessica Blanchard on behalf of people.
Good afternoon, Your Honor. The court, please, Mark Cringe on behalf of Mr. Hajar.
And right around P 3665 on behalf of Mr. Hajar, who's going to present the record. Hajar, please state your full name for the record. Bring it to the record.
All right. Feels like Groundhog Day, but we're here for the PCC as well as, I believe, consideration of some other type of release or alike.
Right.
So go ahead. Well, let me first say this. I received all of the information that you sent me. I believe, Ms. Blanche, you received it.
Yeah, yes.
I don't know if you've had an opportunity to even go through it or.
I mean, I went through it. I wasn't able to verify anything because it was just sent.
Got it. You're right. I mean, it was yesterday, and I want to thank counsel for interrupting my viewing of Olympic coverage while I tried to go through it as best I can. But I mean, I'll let you go ahead, but it's going to be a bit difficult for me to rule on that where the people, I don't think, have had an adequate opportunity to go through or try to verify everything.
Well, I can state as an officer of the court, Your Honor, that we received the 1040s and the 1120s from the accountant. And he verified that these were the tax returns that were filed. I don't know, you can see we got the mortgage statements directly from the mortgage companies, but if I'm
not disputing that anything that you've given is real.
Okay.
I'm not doing that. The people may want to look at something else and in terms of what's there. So there's that issue, but I'm not challenging any of that. The only thing is that when you receive this, it's attempting to try to analyze everything that
I'm looking at that can be a bit problematic to kind of do in a day and a whatever.
In an effort to be, because when, I don't know if the court will recall, I asked to approach the bench, said what kind of financial records.
Right.
And the court had raised an issue about his separate business.
Yes.
In an effort to be completely transparent, well, what I would be anyway, I attached the 1120s for the business.
Yes.
But those are just pass-throughs. Everything's got to be shown on the 1040s. But I didn't want the court to think I was omitting anything, but the 1120s just are a pass-through to the 1040s. So the 1040s are the.
No, I got that because it's an S corporate. So I understood it.
Okay.
I got that.
I just wanted to make sure, but I didn't want to omit those and I wanted the court to have the benefit of it. Your Honor, we were here last, the court had indicated that if he was not able to post a bond, that you would consider, although certainly didn't promise, you would consider the 10% of the $2 million. We have gone through 2 bonding agencies and we have not been able to satisfy the bonding agencies. And we have not been able to get a bond. One was a bonding agency, I think local, and another one was out of state. I forgot whether it was California or California. But in any event, as I stated at the last appearance when we were arguing the bond motion, that there were people that were prepared to post their house, and including Mr. Hajar's house. I actually have an appraisal of Mr. Hajar's house, and if you look at that, plus his friend who is here, Gus, I don't know how to pronounce your last name. Shakira. He has a house on a lake in Bloomfield, which
West Bloomfield.
West Bloomfield.
I remember, I saw it.
Okay. And so if you take those 2 together, you have $1.45 million in equity, probably a little more because.
Well, yeah, but let me stop you there.
Okay.
Because while that's the amount of equity, and maybe what you're running into with the bonding companies, is that were the parties to go and obtain, say, a line of credit or a mortgage of some type, using that property as security, they're not going to be able to do that to 100% of the value. They're only going to be able to do it to 75, 80%
Right.
of the value of the property. So.
Right. And I think actually that is to our advantage, and I'll explain why. So if you hear me out for a minute.
I will.
Okay. So there's probably a little more equity in Mr. Hajar's house than I mentioned in the email that I said that explained everything. And the reason is because if you look, the mortgage was taken out in 2020. We couldn't get the current mortgage statement, but that was the mortgage. So that's been paid down for 3 years. It's probably not significant because, as the court knows, principal doesn't go down early on in the mortgage, and it's been 3 years, but it probably is maybe another 10,000 or something. But I don't think it's hugely significant. But the reason I say is that if we were to post the property, they couldn't encumber it any further. The court would certainly be first in line, and we would be prepared.
No, we wouldn't.
You second in line to the current mortgage, but they couldn't refinance it. That's what I'm saying.
Okay.
But you would be second in line to the current mortgage, but even with being in second in line, there's still 1.459 or maybe just a touch over that in equity. So what we would do, and I've done before, is we could file a quitclaim deed with the court that would be registered with the Register of Deeds. So they couldn't take out any home equity loans or any lines of credit on those mortgages because it would be quitclaim deed, and then the court would hold it. If he doesn't show up, it's the court's property. If he does show up, later on he gets it back. And the reason I say that this is, I think, better security if he posts a $200,000 10% bond plus the 2 properties, he has an incentive, because if he posts a $200,000 10% bond, he's going to get back $180,000. If he paid it with a bail bondsman or bail bondswoman, which he can't do, they would keep the whole $200,000, and they would have the equity in the home. So here you've got an incentive because he's going to get back 180,000 on the 10% bond, and the court will have the two properties, one of which is his very close friend. And but the court has never indicated there's a danger to the community. I mean, that there's a risk of flight. But if he violated his bond conditions, he would be putting his friend, which has over $700,000 in equity, in peril that he would lose all that money. So I think what we've proposed, Your Honor, is a 10% bond plus the two residences, which give another 1.45, let's say 1.46 million plus 200,000. Now you're up to 1.66 million. So you're really close to the 2 million total.
But I don't.
The only difference now is, and it's to the court's advantage to make it a 10% bond rather than a $200,000 cash bond plus the properties. Because it was a $200,000 cash bond plus the properties, he'd get the whole 200,000 back. But if it's a 10% bond, he has to pay a 10% premium to the court for administrative costs. So the court indicated last time that it would consider that 10% bond. I tried to convince the court that we would do more than the 10% bond, and that is by posting the two homes, which puts you really basically at just under 2 million.
Well,
a couple 100,000 short.
But
a little more, actually, 300,000 short.
I'd need to see your proposal that you're laying out to me in terms of quitclaim deeds and everything. I need to see that in writing. I'm
okay.
Gonna outright reject it because of the way the courts are structured. That proposal would in some way have to go. I'd have to send that at least, although it would be the court's decision, to corporate counsel to make sure that they.
Well, because here, let me
those issues. But let me just say this also.
Sure.
I don't agree with the way that you have addressed the numbers. You're addressing raw numbers, but I think you also need to take into account that, and I'm always going to look at it in terms of worst case scenario. So let's say I do that, he takes off, doesn't appear. I now have that money, the 200, but then I have these houses which are encumbered. And I'm and when I say I mean the court would be second in line on any type of foreclosure if it wasn't being paid.
That's correct.
And I know what happens to creditors that are second in line.
Well, but
if it's foreclosed on and then sold.
But there's no question, Judge, that there is considerable equity even over and above the mortgages. I mean,
yeah, but it's not, listen, it's not equity that that the court can do anything with. I mean, I hear you. I hear you in terms of the value, but there's not a whole lot that the court can do with that.
Oh, they could force a sale. The court could certainly force a sale. In fact, if I may.
Yes, but then, okay, you're talking about then a procedure that there's a reason why this is very rarely, if ever, done. I think in the 25 years I've been on the bench, there's been only one other case where I've even considered taking real estate.
Yeah, the court will specifically provides for real estate.
Oh, I know what it provides. I also know it provides for a lot of things that sometimes don't happen.
What I have done this in federal court in forfeiture, and what we've done is we've reached an agreement, and I'm happy to put this all in writing for the court. But that what would happen is that that there would be that the county or the prosecutor's office, whoever, would have the right to force a sale of the house within X amount of days of his failure to appear. But the courts never really saw this, at least my understanding. This court is I've not seen the court be concerned about a failure to appear. What I've understood the court's concern is a danger to the community.
Yes.
And so basically what we've proposed here monetarily, if the court is concerned that the $2 million, which the court said it would let stand, it wasn't going to raise it, but would consider reducing it to a possible 10% bond with a combination of conditions, then you're almost basically in the same spot you would be if it was through a bail bondsman. The only difference really would be that in terms of danger, not risk of flight.
Well, the only difference is that the court becomes the surety.
Well, the court's not the surety is the property.
Oh, no, we do, because then we would be the ones ultimately that should something go awry, that would be executing on the property. So, I mean, in effect, that's what we would be doing.
I just got a note, Your Honor.
So I'm bringing it up.
Yeah, that there is another house that's worth $450,000, which is free and clear. And that we could post. So now you're well over $2 million.
Okay.
Not well over, but you're over 2 million. I shouldn't say well over, but you're over 2 million plus the 200,000. So now you've got basically 2.2 million. And I can prepare the quitclaim deeds. I can do all of that work myself. And present it to the prosecutor in a written order for the court to examine.
All right. I don't have any problem with that. I need the structure of what you're proposing in writing, because while certainly the court, I can make this decision, I also want to make sure that the court and the county are covered regarding this. So I can tell you that I need something in writing that I would be able to potentially send to corporate counsel, review myself, send to corporate counsel regarding this issue to make sure that all of the bases are covered. And then also make a determination, and then make my determination as to whether or not we would go. If you said there's 450,000 on another home?
Correct. Is that?
That's free and clear?
In Livonia, free and clear.
Okay.
And I can, we'll go to the Register of Deeds and, present proof that it's free and clear. But I have a simple solution if you just made it 200,000, 2 million, 10%, but I think the court's already indicated that.
No, I'm way past that, but thank you for this.
I'm always trying to help.
Yeah, I know. Okay. All right. So I need to get that in writing. That's going to give the prosecutor time to take a look, and then that's going to give the court time to do what I'm doing. I want to make it clear. I'm not saying yes or no to any of it. I just want to see the entirety of the package.
Okay. I will try to get something to you by Monday, if not sooner.
Fair enough. And just so that you know, you need to get that to me, and then I'm supposedly on this thing called a vacation, but I'm not sure when that begins. I'm not even sure where the vacation is. When does it start?
It starts 1:30 on the 13th. No, it starts on the 14th.
Oh, I hope you could get this.
No, right. I just want to make it clear so that if I disappear and don't answer.
Okay, I will try to get something to you no later than Monday. And I have sort of a busy day tomorrow, but if I can put everything together, rather than preparing the quitclaim deeds now, I'll put everything in the proposed order of how it would work, and then obviously we'll have to get the quitclaim deeds prepared and so on.
Gotcha.
Okay? Okay. All right, and I'll also maybe call corporation counsel and see what they might require.
Fine.
I'll take that upon myself.
That's fine.
Fair enough?
Fine. Yeah, you can do that. I mean, that's fine. I mean, whatever it is, I'm gonna be sending it there, and just understanding that it's my final decision, but like I said, I want to make sure that everybody's covered.
Okay, and I'll also put in the other property that's worth $450,000 free and clear.
All right.
Can I have a moment with the client, Your Honor?
You may. You may want to, counsel, hit the mic, counsel, just hold on the button. You can lean over, but it's got to be flashing green. Otherwise, believe me, these mics, you got to hold it down. So you got to hold it with that hand. Take that, no, not that hand, the other hand. That hand, just put it on the button. No, come on. Put it on the button. And then use that hand. TOP, and then you can lean over.
I get it. With the court's indulgence, today's the day for the PCC.
It is.
I'd like to put that over one more week with the prosecutor's consent, and I haven't spoken to her about it, to see what we do with the bond, and then as we did the last one. So if the court is agreeable to that, I'll try to get everything, and then we can have a probable cause conference for next Thursday. If he's out, we'll go ahead with it. I mean, whether he's out or not out, we'll make a decision then.
Okay, so let me ask this. Where are we, since you had a lot to say, Ms. Blanche, where are we in terms of discovery and other things?
2 weeks, I was told that, from Tuesday.
Pardon?
2 weeks, my officer told me 2 weeks from Tuesday is when they're gonna get the toxicology back.
Got it.
If that's what you're asking.
Yes, well, I'm asking regarding that, and so. Okay.
Your Honor, she's provided with all the discovery. I think that pertains to this charge.
You got an evidence.com link too, right? You got all the video?
I don't have the video, I just have stills.
I think it would be an evidence.com link. I'm pretty sure whatever I have, I've shared with you, but I'll make sure.
Okay, but I don't know that the videos are all that important anyway in this case. I don't know that there's any dispute over where the body was found and that sort of thing. So.
Okay. I just want to make sure that I understand we're having argument regarding the bond, and I get that, but I also want to make sure that the case itself is proceeding.
It's moving, sure.
And heading forth. So.
Never been my idea to stall a case out when someone's locked up, I can tell you that.
Okay. So you would like a hearing next week regarding all of this, regarding the bond and the like. Okay.
Right, and I'll try to have everything to you by Monday with the understanding that the court will look at the order, say, okay, Mr. Krieger, it's either fine or not fine, and then I'll prepare all the deeds and so on.
Okay, so here's my issue with your timing, is that if you get everything to me by Monday, and let's say you're talking with corporate counsel, you're talking with that and doing everything along those lines, and the court you'd be asking the court to make a decision basically on 2 days. And I don't know that that's a practical way to do it, just timing wise. I just don't. I think we'd get here next week and we'd be maybe further along on some line, but wouldn't have everything.
Well, you certainly wouldn't have the quitclaim deeds until you approve the order, then I would.
No, you're right. But what I'm saying is, I'm not sure that all of the information and everything's going to be here then. Now, here's what I don't mind setting it the 8th. My preference would be to set it on the 13th because I have a PCC prelim docket that day.
The 13th?
And I'm just thinking that would be timing wise, counsel. I'm just thinking if I were to make a decision that we could go along with this, that we could have everything digested, have everything in place and make sure that everything's tied up. That's my suggestion. I will set it for the 8th, but I'm just not hopeful. I mean, I hate to get here and then we're still here and then I push it to the 13th in any event.
Let me just make sure I understand the court. I can do the 13th in the afternoon without a problem. I've got something in the morning in federal court, but so the idea would be to present the order, the proposed order for the bond. You would look it over and then on the 13th say yay or nay, and then I would have to prepare all the documents to facilitate that, like the quitclaim deeds and so on. Am I reading the court correctly?
Yes.
Okay.
That's what I'm looking at. That I just want to make sure we have enough time to say, yes, this is what we're going to do, if we're going to do it.
Okay. All right. Then I will start working on all of that right away.
So, and
And you would want all three properties now to be listed in there, including.
Yes, because and it's not agreed at all on the court's part or anything along those lines. I don't agree. I agree with in some your analysis, but I don't agree in terms of the value in numbers, because I'm looking at it that if at some point I instructed somebody or to get a mortgage on something, I'm not going to be able to mortgage it to the max of that appraisal. That's not going to happen. So I don't think the numbers are as high as you're saying that they are.
If you add in the 450,000, that's free and clear. Now you're up to, oh, I'm sorry. Okay. You're
off of that one. I'm only going to get about 400, maybe 380 if I had to mortgage it. But I mean, we're just looking at it from different sides. I mean, we're still looking at the same thing.
My idea would, you wouldn't mortgage it, you would just sell it. Right?
No, I understand that,
but the county would foreclose on and then get a realtor to sell the property at whatever value it can get.
Yeah.
With interest rates supposed to go down, maybe you'll get even more money. But I'm confident he will.
If I wanted to be in real estate, that's what I'd be doing. That was not my intent.
But I'm confident Mr. Hajar will appear. I don't think there's any risk of that change.
Okay.
Okay, thank you.
Okay, so we'll adjourn probable cause conference and the bond hearing and you are here that day, 13th.
Yes, Your Honor, I'm here
for other things. Yes, it will be, well, my probable causes are in the morning, but I'll set this in the afternoon. What time do you want me to?
2 p.m. Sure.
August 13th, 2024 at 2 p.m.
And I'll try to get. Do you know anyone at Corporation Counsel you could recommend?
I do. I know all of them.
Is there someone that would?
I don't know who would be doing this, so it's probably just to reach out to the listed corporate counsel, because they may go outside on something like this, because it's not a very large office, but I don't know.
Thank you.
Yep.
I'm not gonna make any additional. Judge, I just wanted the court to be aware, Mr. Hajar is requesting doctor. He is having some medical issues. I just wanted.
Right now, or?
No, yeah. I've been having high blood pressure and they check me 160 over 98, 101 constantly, and I asked them to just do something about it. It was not feeling 100%.
But they've been checking you at the jail.
They check me, they tell me they're gonna send me to, they tell me it's doctor, but nothing has been happening for last week.
Okay. So as I indicate to people, I am not a doctor. I have no medical training. I leave that to the jail and medical staff. I've never known this Washtenaw County Sheriff's Office not to respond when you are saying I have these symptoms. They will check them. There may be disagreement as to exactly what's going on, but I've never known them not to make the proper call.
They check it, but nothing happens. And they see the numbers are high.
Okay, and what do you want them to do?
I never took it, I just had a good diet.
So you're not on medication?
I never took medication before.
Okay, then that's gonna, I would imagine, require a whole other set of things. I would talk to medical at the jail. I'm telling you, they're very good. I mean, it's not as though they're not.
Thank you, Rob.
All right, thank you.
Thank you.
Judge, I don't know how to stop this.
What is it?
I have no idea. There we go. I don't know what, that's not my ringtone. I don't know what that.
Is that your phone?
It appears to be.
All right.
Unless Mr. Gannett has authorized something this morning. It's my phone.
I was expecting Copeland stand here.
We would like to set.
Is Mr. Bailey?
Yes, sir.
Why are you standing at attention?
Yeah, you can loosen up a little.
Just relax. Relax. Okay, that's better. You're like stressing me out. I know. She was like, they're like a little soldier. I'm like, and I saw it at the very beginning, and I said, oh, she won't be able to hold that for very long. And then Mansoor kept talking. I said, she gonna hold it. I gotta stop this. Okay. Thank you, Mr. Smith.
Hey, I'm glad that you're in a better mood.
Mrs. Smith, I'm always in a good mood.
I'm like, hey, can I come back another day? Thanks, Your Honor.
Thank you, sir.
All right, bud.
Continue. All right, Mr. Miller. Thank you for signing back on, Mr. Miller.
Yes, Your Honor.
All right, and Mr. Miller, I want to thank you for something else. All right, can I?
Yes, Your Honor.
So before court began, you were on. We had the screen turned on. You were smoking.
It's secret.
Hold on. And my staff told you not to smoke, and you immediately put it out and then apologized for that. And they appreciated the fact that you apologized and that you immediately took care of it. Okay?
Thank you, Your Honor.
So thank you for that, sir. Take care, Ms. Miller.
You too. Thank you.
2024.
Thank you so much.
Ma'am, thank you.
Thank you. And thank you for being so patient with me this summer. It was quite the pleasure. It's been a great experience.
Young lady, it's been my pleasure.
Oh.
And I will just tell you, well, don't be so off. But no, it's been my pleasure. It's also always a pleasure for me to watch young aspiring attorneys as they start out kind of rough. And they're trying to build their confidence, as Mr. Bellinger was saying, and you have. But it's also just, for me, being in this business so long, it's a pleasure watching you just grow.
Oh.
And I have no doubt, I don't know if you're going to be coming back here, but I have no doubt in the future that if you don't come back, I wish you all the best. If you do come back, I'll look forward to seeing you. Because I think, young lady, if you ever doubted yourself, I think you're going to make a darn good attorney.
Oh,
right.
Thank you. This means the world for me. Thank you.
Okay, you take care.
Thank you, Your Honor.
Thank you, ma'am.
Thank you both of this. Yeah.
Are you kidding me? Oh my God. You have got to be kidding me. What is going on today? This is a joke. Today is absolutely an interpreter.
I need an interpreter when I cannot express myself something.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Green, we're going to start bringing people in for you're going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it? Okay.
No patience for that. And trust me, out of the day, I'm sitting up here, I'm the one that needs a drink.